Good afternoon, everyone. Welcome to session 11 of Delhi State Legal Service Authority Learning Series for all Delhi Legal Aid lawyers, open for all law professionals to gather the knowledge. The topic for today is landlord-tenant conflict, law, issues and remedies. We all know during this COVID-19 lockdown, the concerns of the landlords not being paid the rent and the concerns of the tenants of not earning enough to pay the rent cropped up. And there were concerns regarding this. So the session for today would be the discussion over the same, the law for it, what the law says, the issues which the court would be facing as and when the lockdown is over and even in the urgent petitions before the court, and the remedies which each one of us have with us. Before we get to our learned resource person, I would request our learned member secretary, Shri Kavalji Karoraji, to share his vision from each one of us regarding the topic which is there. Over to Kavalji, sir. Yes, sir.
Good afternoon, friends. It really feels very nice to be back with all of you with yet another session of learning series of Delhi State Legal Service Authority. As Shreya told you, that topic for today is landlord-tenant conflicts and COVID-19, law, issues, and the remedies. Friends, getting to know this topic, as Shreya was telling you, there are some questions which comes up in our mind, which erupts in our mind, that why we have chosen this topic, whether the law dealing with the landlord and tenant has gone any change during this COVID-19 period, or whether the post-lockdown period, the issues between these two are going to be resolved in a different manner, or the remedies are going to be different. So all these are very natural and pertinent questions, that when the law is the same, then why we have chosen this topic. Friends, no doubt the law dealing with the subject, that is dispute between landlord and tenant, that has not been changed. But all of us, we are well aware and alive to this situation that has emerged not only in our society but across the globe, owing to the pandemic of COVID-19 and the resultant lockdown which has been declared by the government. Friends, all of us, we are aware that economy of our country that has suffered a serious blow. Situation conceived due to pandemic has resulted in germination of other potent issues which are adversely affecting the citizens of our country, some proximately and some distantly. We all know and can perceive that owing to the situation we are in, many persons, they have lost employment, loss of business, income, earning opportunities, has not only given rise to frustration, but has also increased distances and differences in the relationships, be it that of worker management, be it that of employer employee, husband wife, or landlord tenant. As Shreya was just telling you, that the concerns of the landlords are that they are not being paid rent for these last 3 months now, and tenants, their concerns, their issues are that owing to this lockdown, they were not in a position to do their business, they were not in a position to earn that much to pay the rents. So the issues between intercede between landlord and tenant, as between other relationship, they have cropped up, and they are not only giving rise to legal issues but emotional and interpersonal issues, interpersonal relationship issues between them. So as all these disputes and differences have arisen owing to a different and extraordinary situation which came unprecedented or unanticipated. So thus, for resolving all these issues, all these disputes, with the law remaining the same, we have to look for possible solutions and remedies in a different perspective, except for looking into the perspective what law provides, what the law is there, or what the remedies are provided in the laws. We have to look for the remedies, we have to look for the solutions in a totally different perspective. We need to think differently, we need to think out of the box. Friends, because of this extraordinary situation and the present spread of coronavirus, we all know that courts across the country, they were forced to restrict their functioning. Resultantly, the filing of new cases, that was also restricted. And we all know that once the normalcy is restored, whenever we are going to have the normal functioning of the court, although we do not know that how far that period is, but once it is started, we can always perceive that there will be inundation of new cases of all types, for which we all need to be ready and geared up. Friends, courts, judges, lawyers, and legal service authority, of which all of you are an integral part, together we constitute as service provider, and litigants are the consumer of these justice. So अगर हम ये देखते हैं कि कोई भी सर्विस प्रोवाइडर, चाहे वो आपका ये टेलीफोन से रिलेटेड है, चाहे गैस से रिलेटेड है, whatever is the service provider, that service provider remains accountable and answerable to the consumers for the efficient, effective, and seamless services. So are we to the consumers of justice, so are we to the litigants, so are we to the legal aid seekers, so are we to the aspirants of justice. Doors of the court or of authority for these aspirants of justice cannot remain shut for a longer period of time. We at Delhi State Legal Service Authority, we are committed to our constitutional obligation of providing this access to justice for whatever be the situation. We are committed to our goal, we are committed to our motto, and this commitment is not just a formality. हमें सिर्फ एक formality sake और name sake access to justice, एक lawyer आप में से किसी को case assign कर दिया, that is not going to end the issue. We have to make sure that whatever access to justice or whatever legal aid we are providing to the consumer of justice, to the legal aid seeker, that should be of quality, that should be of such a quality that the consumer of justice should not feel कि मेरे को जो lawyer provide किया गया या मेरे को जो assistance provide की, that was only for the purposes of fulfilling a formality. This should not be the feedback which we would be getting from the legal aid seeker. So in order to say pep up ourselves, in order to increase our knowledge, in order to increase our quality, and in order to sharpen our skills, to enhance our knowledge, and to increase our capabilities, we have started this learning series in order to convert this period of crisis into an opportunity. So we have converted this, whatever they say, that many says that this is a situation of crisis, but I feel at Delhi State Legal Service Authority that we should take it, we should grab it as an opportunity to enhance our quality, to enhance our skills, to sharpen our knowledge. So today, to help us in the crusade of capacity building and for finding different and extraordinary solutions to the problems which have erupted amongst the landlords and tenant owing to unprecedented and uncalled for situation of COVID-19, we are fortunate to have amongst us a senior advocate and a mediator, Shri JP Singh. He has adorned different caps in his journey of say last 4 decades now. I was just told by him before this program that he joined this legal profession in the year 1981. So it's almost 4 decades that he is in this legal profession, and being an expert mediator himself, he has mastered the art of thinking out of the box so as to find solutions for the problems of all those rival parties which comes to him. And I request all of you to hear him with all concentration at your command and try to gain from his experience, which he's going to epitomize in this talk of his. I'm very thankful to you, sir, for having accepted our request to speak to our panel lawyers on this particular topic, which I feel is the need of the hour, as shortly we are going to have large number of cases, large number of disputes between landlord and tenant, how to go about that, whether as most of these cases would pertain to commercial cases only, as many a times we have seen that most of the shops, they are given on rent, and because of loss of business, tenants are not in a position to pay rent to the landlord, and most of these cases are going to end up in commercial courts only. And before going to commercial courts, as section 12 of Commercial Courts Act says, it mandates that pre-institution mediation has to be there. So I'll request all of you to gain from the experience of Mr. JP Singh, who is an expert mediator himself, that how we should be going about to solve or to deal with the problems of all those persons who would be coming to us post lockdown period. So thank you all. Stay safe. Over to you, Shreya, for a formal introduction of our speaker for the day. Thank you.
Thank you so much, sir. So the speaker, sir, has already shared with you is Senior Advocate, High Court of Delhi, Shri J.P. Singh ji. Sir did his graduation from Hindu College, Delhi University. He did his law from Campus Law Center, Delhi. Already shared with all of you that it's been 4 decades that he's been in legal profession. He joined law in, he did his law in 1981. He's known for his experience in arbitration, dispute resolution, rent matters, corporate law, and intellectual property. We are indeed privileged to have him amongst us for a topic which is the need of the hour, which not only legal aid lawyers, but also is of importance to each and every individual in this country. So over to JPC. Yes, sir.
Hope all of you are doing well. These are trying times of COVID-19. But as they say, the show must go on. We are learning all the time, and the learning must go on. So, welcome to this webinar. According to sages of ancient India, there are 3 fundamental processes at work in the universe: creation, preservation, and transformation. We are born, we grow up, and then we die. What is COVID-19 after all? COVID-19 is simply a virus like flu or cold. It has mutated itself and from animals has found a place to grow in human beings. Yes, it is contagious and will remain around for a while till our bodies develop antibodies to effectively fight and finally eliminate them. So that will be the end of COVID-19. Now, COVID-19 is a creation which has pushed us into quarantine, that is, state of self-preservation. We are also witnessing a transformative change in the kind of conflicts this pandemic has thrown up and the way we look at those conflicts and how do we resolve them. Disputes that have spiraled during this period of lockdown are relating to waiver or exemption from payment of rents during closure of industrial or commercial establishments. Tenants claim that they have not been able to use the premises and are hence entitled to suspension of rent. To add to this confusion, there have been several government orders issued to grant protection to a particular class of tenants, for example, workmen, labor, students, etc. Now let us understand the kind of tenancies we are concerned with. There are protected tenancies which are covered by some statutes like Delhi Rent Control Act in Delhi. Then there are purely contractual tenancies which are governed by the Transfer of Property Act. Issues arise with respect to residential premises and commercial premises, as also properties which are owned by individuals and others which have been let out by public authorities or government. Now, the dispute I referred to above has several nuances. There is the issue of force majeure, whether COVID-19 and consequential lockdown would entitle the tenants to claim any relief from payment of rent as they have not been able to use the premises. Next is the doctrine of frustration. And finally, do any provisions of the Rent Control Act or the Transfer of Property Act provide any relief to the hapless class of tenants which find themselves out of the premises on one end of the spectrum while facing a financial ruin at the other end? I feel that the present situation does not actually very much hurt old tenancies in the matter of payment of rent. In respect of such tenancies, the rents are quite low. They have not grown in line with the value of money, which has seen a deep decline. This issue may also not be relevant to residential premises as you continue to reside therein and there is no cause to seek suspension or remission of rent. Now, where is the real problem? The real problem lies with commercial tenancies and especially those of recent vintage. The rents which were fixed between the landlord and tenants are keeping in view the current market rates. And now in face of closure of business, the tenants, including multinationals, are finding it very difficult to remain solvent. Let me give you some shocking details. In the United States of America, nearly 33 lakh people have lost their jobs due to COVID-19 and consequently, there is no income. They can't pay their rents. So what happens? 23 lakh tenants in the US are facing the prospect of getting evicted from their homes. Now, we can keep on debating when the vaccine will come, but you must realize rents are due every month. The big corporations can still afford to negotiate with their landlords. But majority of people now are looking at disruption of education of their children, loss of their belongings, and the roof over their heads they call their home. Let us deal with now, in these circumstances, what are the legal issues involved? Let me start with force majeure. What is force majeure? Now, force majeure is a legal term in French laws and was derived from the Code of Napoleon and applied for the first time in Civil Code of France. Black's Law Dictionary defines it as an event or effect that can neither be anticipated nor controlled. This term includes both acts of nature like floods, earthquakes, and acts of man like riots, strikes, and wars. Force majeure occurs when the law recognizes that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which the performance is called for has rendered the performance impossible. Now, we have to look at a force majeure clause in a contract. If it is there, it frees both parties from contractual liability or obligation when prevented by such events from fulfilling their obligations under the contract. Now, this clause, even if it is there, does not excuse a party's non-performance entirely, but suspends it for the duration of force majeure. Now, let's look at the provisions of law. Now, having known now what is force majeure, let's look at the provisions of law. In the Indian Contract Act, there is no definition of force majeure or neither it is referred to as such. A typical force majeure clause in an agreement would first define the events that would constitute a force majeure and would then specify what consequences would follow if such an event occurred. Now, many contracts may not contain the force majeure clause to claim any benefit due to COVID-19 outbreak, because as I told you about the definition above, this is neither a man-made, in that sense, a man-made disaster, nor is it, you can call it an act of God. So, according to Indian law, a force majeure clause is not ordinarily an implied term of a contract when such a clause is found in an agreement. It would be governed by Section 32 of the Indian contract. Now, let's see what does Section 32 say. Can I have Section 32 on the screen, please? Now, Section 32 says, enforcement of contracts contingent on an event happening, contingent contracts or to do or to not to do anything, if an uncertain future event happens, cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. So now, when most of these leases must have been drafted between the landlord and tenant, do you think at that stage they could have ever envisaged a situation like COVID-19? So most of the contracts between landlord and tenant would have no such clause like the one envisaged under Section 32. Now let's say if the clause did exist. Now what is the consequence of that? If a clause did exist, the tenant will be required to show what? Force majeure was beyond its control to prove that the event itself has caused the lessee to fail to perform its obligations. It's not COVID-19 which has prevented parties or the tenant from actually occupying premises. It's the quarantine which the government has imposed, because of which the premises can't be used. So therefore, the user of premises is not directly concerned with COVID-19. Then the fact that if the tenant was compelled to perform its obligation, it would cause economic hardship or inconvenience is not a sufficient ground to take advantage of the force majeure clause and to say, I'm not going to pay the rent. So economic hardship does not come within the domain of force majeure. Now, if there's an alternative way to overcome the effect of force majeure, tenant would be required to take that alternative method and still would not be excused from the payment of rent. Tenant cannot rely on the force majeure without trying to mitigate or explore alternative ways to perform the contract. So in case there is a force majeure clause, it will be examined in light of Section 32 of the Indian Contract Act. Now let's say there is no such clause. What happens then? For that purpose, you have to go to Section 56 of the Contract Act. Can we have Section 56, please? Now, if you see Section 56, do impossible act. An agreement to do an act which is impossible in itself is void. See, this is actually called the doctrine of frustration. You must realize that, no contract or no law can compel you to do something which is impossible. The doctrine of frustration is really an aspect or part of law of discharge of contract by reason of supervening impossibility or illegality of the act agreed to be done, and hence within the purview of Section 56 of the Indian Contract Act. Now, if you see further, it says a contract to do an act which after the contract is made becomes impossible. Now, what does this aspect of the section deal with? Now, the essential ingredients of this part of Section 56 are that there should be a valid and subsisting contract. Number two, there must be some part of the contract yet to be performed. And number three, that after the contract has been entered into, it becomes impossible to be performed. Now, instead of telling you about this section, let me tell you how the Apex Court dealt with and interpreted this section with respect to a lease agreement. Now, the Apex Court, in case titled Raja Dhruv Dev Chand versus Raja Har Mohinder Singh, this is AIR 1968 Supreme Court 1024, held. Section 56 of the Contract Act will not apply to lease agreements. Because as I told you, one of the conditions is that the contract must be subsisting and there must be something to be done. What does the Supreme Court say in that matter? A distinction was drawn between a completed conveyance and an executory contract. It was said Section 56 will not apply where there is a completed transfer. In the present instance, in cases of tenancies, lessee has been put into the possession of the premises and there is nothing more to be performed. Therefore, the Supreme Court said tenant cannot invoke waiver or suspension or exemption from payment of rent. Now, if Section 32 and 56 do not come to the aid of the tenant, now where does he look? Rights and liabilities of lessor and lessee in respect of immovable property is governed by the provisions of the Transfer of Property Act. Transfer of Property Act deals with rights in respect of immovable property. And here, since Transfer of Property Act is a specific law, and it deals with such a situation as we are talking about, which is contained in Section 108, subsection B, subsection E of the Act, and therefore, Transfer of Property Act in any event would supersede the doctrine of frustration contained in the Contract Act, which is a general law. Now, let's see what does Section 108, subsection B, subsection E say, and when does it apply? Now, if you see Section 108, subsection B, can you just go up a little? The 108 on the screen, can I have subsection B, please? Yes. Rights and liabilities of lessee. And if we go to, if it says by fire, tempest or flood or violence of an army or of a mob or other irresistible force, any material part of the property be wholly destroyed or rendered substantially and, can we go up a little? Unfit for the purpose for which it was let, the lease shall, mark these words, at the option of the lessee be void. Provided, of course, let's leave the proviso out. Now, what does it say? The lease would be void at the option of the lessee only if, where any part of the property is wholly destroyed or rendered substantially and permanently unfit for the purposes for which it was let due to fire, tempest or flood or violence of an army or mob or other irresistible force. And therefore, for the conditions to apply, one, there must be complete destruction of part of the property which is permanent in nature. And temporary non-use due to COVID-19 obviously would not be covered under 108. So therefore, 32 doesn't apply, 56 doesn't help, 108B doesn't help a tenant. Let me summarize the position of law for you. Section 32 of the Contract Act will only apply when there exists a clause in the nature of force majeure providing for waiver or suspension of rent. If there is no such clause, Section 32 will have no application. When will Section 56 apply? Section 56 of the contract is not applicable to lease agreements and similar situated contracts because they are executed contracts and they are not executory contracts. So therefore, Section 56 is ruled out. Now, so far as Transfer of Property Act is concerned, in the absence of any contract or contractual stipulation contained in the lease, the provisions of Transfer of Property Act governs the tenancies and leases, but temporary non-use of premises due to lockdown cannot be construed as rendering the lease void under Section 108, subsection B and subsection E, and therefore a tenant cannot avoid payment of rent. And you must also realize this also, if the lease is to be voided at the option of the tenant, then there has to be a surrender of the premises. And if only once the premises are surrendered, the liability will stop, or otherwise the liability to pay continues. So that takes me to the question now, as far as law is concerned, I do not see anywhere that the same comes to the help of a tenant. Now let's look at comparative hardship. See, so far as landlord is concerned, landlord depends on the rent, or he may be in need of the premises itself. Then he has insurance to pay, he may have property taxes to pay. You know, some people actually let out properties so that they can service their loans. And if they do not get paid the rent, how do you expect a landlord, to survive in these circumstances? So therefore, it's actually a hardship on the landlord too. But let's see what happens to the tenant. Tenant, because of the present circumstances, has already lost his source of income. And especially if it is a commercial property and is lying closed, there's no business. Because he has no business, he can't pay even rent for his residential premises if he's a tenant, so far as residential premises are concerned. So what happens? His family life gets disrupted, and ultimately he even loses the roof over his head. Now, so what is to be done in these circumstances? All that can be done, as I see, is you can invoke the equitable jurisdiction of the courts. Where does that take you? Now, this has been answered in a very recent judgment of the Delhi High Court. This is Ramanand versus Dr. Grish Soni, which is Rent Revision 447 of 2017. And the issue was decided during this lockdown period on 21st of May 2020. In this judgment, whatever I have explained to you above, on all counts, the court has held against the tenant. Now, if that be so, what is the remedy for a tenant? So all I can see, this is actually a humanitarian question. This is not a question relating to statutes or contracts. This is where a tenant needs to reach out to the landlord. And this is, to my mind, a best case for mediation under the guidance of an experienced mediator. Now, landlords must look at it from this particular point of view. What are the alternatives for the landlord? If the property is to be relet, there will be no ready tenant, because the new norm will be work from home. The property may lie vacant for a while. And in any event, the landlord is not going to get the current market rent which he is getting from the property in question. There will be shortages of tenant, and even if, let's say, let's say he files a suit for recovery of the rent, he gets the possession, but execution of that decree will depend on solvency of the tenant. If the tenant himself itself is insolvent, how does the landlord recover the amount? In matters of commercial properties, it will be covered within a commercial dispute, and now Section 12A of the Commercial Courts Act 2015 in fact mandates that the matter, before it's actually filed, must compulsorily go through the process of mediation. And in case under 12A, if a settlement is arrived at, it has the force of an award and consequently can be executed as a decree. So therefore, it's not that the landlord needs to spend too much of money. So therefore, compulsory mediation is now even mandated under the Act. What are the options? What the negotiations in a mediation can throw up? See, there can be scaling down of rent. Parties can agree, because instead of keeping the property vacant, the landlord can agree, okay, let's scale down the rent. Then it can be a case of deferred payment. Parties can agree that the amount be paid in installments, the current rent can be paid in installments. Parties can also agree on waiver in case, let's say, it's a temporary phase. And in other instances, let's say if the tenant is able to recover and is in a position and his business is restored, he can even agree to pay the current position of rent after his business is restored. And I am given to understand that the Mumbai-based Lodha Group decided to allow rent waiver for its retail partners after the government announced the 21-day lockdown in wake of COVID-19 pandemic. So therefore, as I said, this is basically a humanitarian issue. Parties have enjoyed a relationship. Tenant and landlords also enjoy a relationship. It's unfortunate that these circumstances are thrown up. It's equally hardship for a tenant as it is for a landlord. Now, other options which can be explored are deferred payment can have an element of interest. Parties can renegotiate their terms of tenancy, and depending on the requirement of the landlord or tenant, the same can be increased or decreased. Then an option can be given to the tenant to match the market rate of rent when the negotiations take place in future and the circumstances have improved. So therefore, what I can see right now is a great chance for mediation to succeed. Mediation has already played a great role so far as India is concerned. And from my experience, I can tell you that in court-annexed pending matters, 60 to 68% in Delhi High Court has been the success rate. And in pre-litigation mediation, including IPR matters, we have seen that the success rate has been nearly 80%, because parties' conditions or situations have not hardened. They have not taken hardened positions, and therefore they are willing to negotiate. So looking at the present situation, where, as I said, we as Indians are mostly, we believe in relationships. And that is why it was said that mediation in India would succeed, because we are not actually right-based. We are not willing to sue our neighbor merely because of a right to sue my neighbor. But because I give a lot of weight to relationship, I'm not willing to sue my neighbor. Then let's look at even cases of properties which are with the government, where the government is the landlord or PSUs are landlords. In view of the orders, the administrative orders which have been issued by the government from time to time, I think this is time for the PSUs and government to consider what I have talked about, the options in mediation more sympathetically because of the conditions which are now prevailing. This takes me to our training when we did our training in United States in so far as mediation was concerned, the training of teachers training. One of the professors there, Professor James Holbrook, said the difference between the American mediator and the Indian mediator. He summarized it thus. He said, the American mediator is the one who actually settles dispute. He's a settler of disputes. And the Indian mediator is actually a healer of disputes. Mediators in India heal disputes. When I said we value relationships, I'm sure this is the time for tenants and landlords to sit together. Because as I said, we must have a humanitarian approach, a sympathetic approach, because the conditions which are prevailing are not the making of the landlord or the tenant. And we should actually sit together and try and find a solution. And the best way to find a solution is through mediation, because this is the only process which deals with emotions of the parties and relationships. In court, you will get a judgment. As I said, you may get a judgment, but it may not be easy to execute. Therefore, why, as they say, cut the face to spite your nose instead of keeping your property vacant? These are circumstances which are beyond the control of parties, and therefore a sympathetic, a humanistic approach needs to be taken, and parties actually need to sit down and resolve it, because this is the only solution which will be win-win for both the landlords and the tenants. Thank you so much.
There's a question, sir, which I would request every participant to put questions in the chat box, which could be put to the learned speaker. So there's one question by Advocate Ranjan Kumar. I've missed onto that, but I've written it. Corona being unresistible force, why Section 108B shall not apply specifically for commercial property?
See, if you read the letter of law, 108BE only comes into play when part of the premises are destroyed and permanently destroyed. And that too, the option is given to the lessee to give up the lease, surrender the premises, and then seek waiver of rent. So therefore, unfortunately, the way it may be worded, there is no way that COVID-19, which only temporarily removes the tenant from the premises, can be used to invoke Section 108.
I think everyone has responded more on the fact that it's a very informative session and they've really enjoyed the session. But I think they're writing. Oh, there's another question, sir, by Gaurav Kohli. He says Indian mediators are healer of dispute and American mediators are settler of dispute. All this could happen due to persons like you who wholeheartedly devoted time for mediation. Oh, that's a great thing.
Thank you so much.
I thought it, and the way it's said, of course, that's an appreciation for you, and we are indeed privileged to have you amongst us. There are a lot of other appreciation. Because there's no question, let me put the appreciation to you. So they say well explained session, no questions. So this is a nice session, informative, and this is all. So I think we can conclude now. I would rope in our member secretary also and conclude. Yes, I think he's also here.
Thank you very much, sir. And our chat session and chat box that clearly reflects the way you presented it and made it very clear to all our legal aid lawyers that what would be the legal position for the tenants and, of course, for the landlords also. And the way you have explained it, that neither Section 32 nor 56 or, for that matter, 108 of Transfer of Property Act, which specifically deals with the immovable property and inter-se relationship between landlord and tenant, lessee and lessor. So that won't come to the.
Shyam, I'm really happy in case if I have been able to actually,
Sir,
add to the knowledge of the others, because I always believe when one teaches, two learn.
definite.
So I am
True.
also learning
There,
at the same time.
there
So there are
so many
questions
of the.
opening now. Should I put the questions? There are
Yeah,
questions
yeah.
coming in.
Yeah,
Yeah,
I'm here.
I'll
yes.
just open those
Would be
questions.
glad to answer.
Yeah. So some market associations, some is written, market associations are working to mediate between the parties. There's this question by Kanishk. I think that's the concern. 1 second, I think, because everyone has started typing. So, what clause contains that the property becomes unusable because of any government order or notification? Would this be covered then? I think is the question clear?
See, what prevents you from going to the property is COVID-19. COVID-19 was never in a contemplation. So therefore, you will have to, the force majeure clause, even if there is a clause, will have to be very strictly construed. See, it may not ultimately completely answer so far as waiver of rent is concerned. It may merely postpone the payment of rent. So therefore, it will all depend on the terms of the clause, how it is to be read.
Yeah. So another is by Rahul J. He says, can a tenant invoke equitable jurisdiction of court and residential tenancy?
See, that's what as I said, you see, your equitable jurisdiction so far as residential property would be that, you've lost your business and therefore you're not in a position to pay for rents.
True.
Even in America, they have not succeeded because governments, unless the government comes to the rescue, you see, this is maybe the time when the government should realize, from people who can actually afford to pay, realize some cess and help these people. I mean, that's all I can say. But so far as law is concerned, I don't think, in terms of what the provisions of law which exist today, it can help the tenants in the present circumstances.
So there's another question, and that's come in the capital. It says, why COVID is not treated as act of God? I think I automatically joined my hand.
So flu is born, tomorrow you can say you have flu, then flu should be act of God. See, because today we do not have a vaccine for this, doesn't render it an act of God. Yeah, and then they will have to be read in conjunction with the terms that you use in your clause. You see, act of God, you will say like fire, like flood. So if you define them, earthquake. So if they are defined in that manner, so this will also take color. Whatever is the provision that you have will take color from the earlier provisions. So will this COVID-19 be a part of any one of those three that I talked about? I don't think so.
So another question on screen by Advocate Lohit. He says that one is working in agricultural land on sharing basis for more than 25 years. Can he claim land from landowner? I think
See, those are remedies which you'll have to seek under the statutes. But so far as payment of rent is concerned, what we are actually presently concerned may not be a part of this particular topic. So, I mean, if we get involved in any other discussion, then probably it'll make it very wide.
Yeah, by Rajbir Singh. If the tenant has terminated the lease but still holds possession, is he liable to pay?
Yes, that's what I said. He has to surrender property. Because if the premises, you can't continue you can't have your cake and eat it too.
True.
You can't continue with the property.
Another one by Kunal Agarwal. What will happen to those tenants who are on Pagdi in Delhi?
Pagdi is not recognized, especially if you look at, that's why I said, if you're protected under the Delhi Rent Control Act, the rents are meager as compared to the market rent.
True.
So you are not really affected. These are properties or premises where you may not be really affected in terms of rent. Of course, your business may close down. You have employees to pay. It can cause economic hardship. All that is there. But so far as rents are concerned, when I look at these premises, the value of rupee today is hardly anything. I mean, so if you're paying 700 rupees or 800 rupees, that's you spend on your vegetables, in one time when you go out. So therefore, paying rent for the whole month at 700-800 rupees actually doesn't affect these kind of tenancies in these present circumstances.
So another question: what has been and what would be the importance of putting post-mature clause while drafting contract pre and post-COVID?
Yes, this is where lawyers' tact will now come in now. I'm sure this makes us wiser. As they said, the COVID-19 has taught us so many things. Use of technology, today, like we are talking to each other. In normal circumstances, we'd be actually sitting across each other and talking to each other.
On one table.
On one table. And
So
today
we're
we are...
at home.
Yes, and today we are all, spread out all over Delhi, and I'm sure everywhere else, and we are sitting and talking to each other. So therefore, we'll have to be careful. This is where the lawyers' tact will come in. When you draft clauses in future, you'll have to keep such contingencies in mind, because unless there is a clause, you will not get the exemption.
So this is all. So I can read this. There's an appreciation and comparative study of all three relevant legal provision defined in a clear manner. Learning made easy. Thank you. And sir, but again, one question is cropped in. We can take this as a last question. So if a client or tenant reaches us, then we should go to the landlord, and I think he's just following what you just said. So we can conclude now. And thank you so much, sir.
Thank you.
Share something.
Thank you so much.
Thank you, Shreya. Thank you so much for calling me.
And we would like to apprise everyone that the next session this time would be on Saturday at 12 noon instead of 3 p.m. And we would be having Mr. Vikas Pava, Senior Advocate, High Court of Delhi, for a discussion on dimension of judicial discretion in bail matters with special reference to special laws. Reason I've mentioned it today is because we always do it at 3 p.m. On that day, we are doing it at 12 noon. So look forward to having you all on Saturday as well. And thank you so much, JP Singh sir, for all your time and for I think the appreciation on the chat column says it all. And thank you, Kaval sir. So we can conclude the session now. Thank you.
Thank you. Thank you so much.
Thank you, JP Singh.